Okay, thank you for joining today. So we've now come to our second session, our innovative technologies in computing unit. So today we're going to look into understand the impact of technological innovation on the computer industry. So in this unit, the learner will now develop understanding of innovative development in technology and the impact on the other industry. So before we dive in, I selected a short video which will now give us an overview of what we're going to learn in today's session.
Hey, welcome to today's video. I'm Rick Chapo with DMCAagentservice.com. So today we're taking a look at copyright versus trademark versus patent. This is an area where there could be some confusion. So hopefully stepping back and looking at these three main categories of intellectual property will help you understand each one. So let's start with copyright. Copyright is the right to exploit a work of authorship. Original authorship, actually. And so let's just look at a classic example, the Harry Potter books. So J.K. Rowling decides to write another Harry Potter book. When she finishes, she's automatically granted what's known as common law copyright. Now, this form of copyright is pretty weak, so she's actually going to want to go ahead and register with the Copyright Office to get a stronger form. And if she does that within 90 days, she's granted additional rights under copyright law, and so she's going to do that. Now, once she has that in place, how is she going to exploit that work of authorship? Well, for an author, their traditional approach would be to work with a publisher. She would sign a contract with a publishing house, and she would give that publishing house the right to make copies and sell her book. And in exchange, she would get a healthy advance and royalties on each sale. And so in that scenario, she has exploited her original authorship under copyright law. Now, obviously, she can do it in other ways too. She can sign a deal with a movie production company to turn the book into a movie, maybe audiobooks. There are different approaches to exploiting that authorship. But again, we're going to give the person who took the time and effort to come up with this creative work the right to, quite frankly, make some money off of it. Now, there are cases where people don't make money off of it. If you look at open source software, for instance, people will create it just as, like a goodwill effort as part of the online community or something of that sort. But generally we're talking about exploiting it for some type of financial benefit. The original work of authorship, of course, doesn't have to be a book. It can be anything that's creative, software code, images, music. There's a variety of different areas. So if you're interested in looking at those, you can go to the Copyright Office website, and they have actually some what are called circulars, which give you a pretty good idea of the different things. So again, we're talking about the right to exploit a work of original authorship. A trademark is a word, phrase, or symbol that distinguishes a source of goods for consumers. Okay, this is really important. So what we're talking about is basically giving consumers confidence that when they see a particular word, phrase, or symbol, that the goods that are being sold under that word, phrase, or symbol have a certain quality. So let's talk about tires. Okay, well, how about Goodyear? Okay, we all know Goodyear tires, and you have a particular opinion regarding the quality of those tires that you associate with Goodyear. And so when you see the Goodyear name, or you see the Goodyear little flying foot thing, the symbol, okay, that's Goodyear, you associate that. And so maybe you buy it, maybe you don't. It doesn't really matter. But you have that confidence that when you see that name and that symbol, you know what you're getting. Now, if another, cheese ball company in China, puts together some really, horrible quality tires, and they call them Goodyears, let's say they had an S to the end of it. At that point, are you going to be able to recognize that, hey, this is a different company, it's a Chinese company, and maybe they're making, crappy tires that are going to blow up after a couple miles, that are going to be much lower quality. And so for consumers, that could be confusing. And in trademark law, when you have a trademark infringement claim, that's exactly what is alleged. That one company has used a word, phrase, or symbol that is so close to the trademark of another company that's causing confusion for consumers. So a trademark is a word, phrase, or symbol that distinguishes the source of goods. Let's use another example. If you see a swoosh symbol, kind of that round teardrop bending up symbol, you are almost immediately going to associate it with Nike. That's their symbol, and everybody kind of knows what it is. And so if you are interested in sports apparel or something of that sort, and you see that, well, you expect a certain level of quality. You're buying a Nike product. Again, you may think it's great. You may think it's terrible, whatever. But you have confidence that when you see that symbol, you're getting, whatever it is that you expect. And if you got something radically different, well, that would cause all kinds of problems in the consumer market because people wouldn't be able to trust in the quality that they thought they were getting when they were buying something. So that's a trademark. Now, patents are something kind of entirely different. A patent is the right to exclusively exploit an invention. And so what we're talking about here is actually fairly broad because people are really creative. So there are a lot of different types of patents. There can be patents for processes, different types of machines, all kinds of different things. And really, frankly, you'd probably want to talk to a patent attorney at some point if you're getting anywhere near, issues related to patents. But basically, the idea here is that if somebody invents something, it's unique and something new, then we're going to give that person the right to exploit it, much like in copyright. The author has the right to exploit the book they just wrote. So we're going to give them the right to exploit that invention for, a certain period of time, or rather lengthy period of time. And the reason we're going to do that is because we want to promote inventions. We want people to go out and invent things. And if there was no patent protection, well, why would people go out and invent things? There would be much less emphasis to do so, much less motivation to do so, because here's what would happen. I would go out and let's say I invent something, some form of software that works, is going to revolutionize the online market. And I put up my crappy little website and I launch it, and I've got, my entire capital budget for launching this business is the $400 I have on my Capital One credit card. Okay, well, Google happens to run across my website, a week after I launch it, and they take a look at the product and they say, wow, this is amazing. This is going to revolutionize everything. And so they buy the product from me for $199, and then they just reverse engineer it and make their own copy and go out and sell it. Now, who's going to win that battle, me or Google? And the cold hard truth is Google has billions of dollars. I have $400. I think we know how that's going to go. Not well for me. So with patents, we want to give that exclusivity to the invention, to exploit the invention to the person who created it, because we want to reward them for doing that. And we want to promote other people going out and trying to create inventions. Now, each of these subjects is obviously much more complicated than this simple summary, but the idea here is to give you, kind of an overview of what applies to what. If you are online and you're building a website, typically copyright and trademark are going to be your biggest concerns. If you're developing entirely new products from scratch or new goods, then patent may well come into it. But those are basically the three distinguishing areas. There are also lots of caveats with these subjects, some things that are protected, some things that aren't protected. Under copyright, you have things like the DMCA and fair use. With trademarks, we have issues of, you can only trademark really something that's unique. So I can't go out and trademark the word internet because it's a commonly used phrase. So that wouldn't be covered with patents. There are all kinds of issues about, is it actually something unique that you've created?
Okay, so this video introduced copywriting, trademarks, and patents, which we will cover during this session. So from today's session, we're now looking into innovation and ethics and how these have been affecting the humankind. So as we can see, technology innovation is one of the key elements when it's driving human process. As we all know, new technology also raised with ethical questions. So we need to question this technology and see if they are morally or legally ethical, and we have to also see how if they have a serious impact on the society or the environment and pose new risks. So as we all know, when they launch a new software or a new technology, you never know how this is going to be. So you can predict, and therefore it is important to have risk assessment where we can now evaluate what could be the potential risks of launching this new technology on the market. So when it comes to problems related to ethical technology innovation, we can see that the main problems from ethics of emerging technology is the problem of uncertainty. So how to deal with the uncertainty of future products, use and consequences, and associated ethical issues that will result from emerging technologies. So as you can see, technology ethics is simply a field of study that will seek to understand and resolve moral issues that surround the development and practical application of technologies. So when it comes to developing, exactly, there is always some issue that will now be related. This could be due to environmental issues, sustainability issues, or human computer interaction issue. So therefore, this study will now have to point out these issues and evaluate on what could be the pros, cons, future implementation, or the solutions related to them. And as you can see, tech ethics focuses on the subject, such as relationship between technologies and human values, and also the well-being. So we do have a ethical dilemma, where we can now split them into two parts. So in the first part, we're going to look into ethical dilemma or ethical paradox, which is a decision-making problem between two possible moral imperatives. So neither of which is ambiguously acceptable or preferable. So we can now see this, how the complexity arises out of the situational conflict in which obeying one would result in transgressing the other one. While with the second dilemma, this we also known as a moral dilemma, where situations in which there is a choice to be made between two options, neither of which resolves the situation in an ethically acceptable fashion. Entrant technology, this is now related, has now completed all the stages of development process in sometimes called as entrant technology, such as technology which are associated with number of development products, process or procedures of techniques that are widely used for society, and they are familiar use as known of impact on society. So when it comes to the ethics of entrant technologies, these are now able to address, evaluate, and direct a greater set of existing phenomena. So what happens is that we can now ethically assess and recommend modification to specific products, and we're now able to tailor them based on the request of the client. Emerging technology, we all know what they are, so we've mentioned them in our previous session, such as big data, blockchain, quantum computing, Internet of Things, and so on. So when it comes to this new innovative, they are still development, and they are expected to have a large socio-economical impact. So they are now in the sense that the employee can concept methods and techniques and cannot be submitted under existing technologies. So when it comes to emerging technology, there are still technologies in the making. They are not fully developed and they're entered in the society. So some of them are going to be the future and some of them are already with us. When it comes to ethics in emerging technology, these will now tend to have a focus on research and development of this technology, as these are realities that can be assessed and redirected on the basis of ethical assessment. So what is ethics in emerging technology? They can only make use of speculative or maybe approximate data about future products, uses and impacts. But what they do, they will now keep the promise of early intervention when the technology is still incomplete. So when it comes to ethics of emerging technology, this will now focus in large part of emerging enabling technologies, which are now expected to result in waves of innovation across different sectors and society. Now we're looking into the ethical approaches in emerging technologies. So there are 5 core to this approach. We now have generic approach, anticipatory approach, ethical risk analysis, and experimental approach. And lastly, we have participatory and deliberative ethical approach. As we saw before earlier on the video, we now look into the difference between copyright, trademarks, and patents. And we also need to mention intellectual property, which refers to the creation of the mind, such as innovation, ideas, literally and artistic works, design, and symbols. So intellectual property is protected in the law. For example, these are patents, copyright, and trademarks. So we've looked into the video. A patent is a form of intellectual property that gives its owner the legal risk to exclude others from making, using, and selling and importing innovation for a limited period of years. Copywriting is now going to protect your work from and stop others from using it without your permission. So automatically you get copyright protection when you create original literacy, dramatic, musical, artistic work, including illustration and photography, and so on. When it comes to trademark is simply the type of intellectual property which consists of recognizing your logo, your brand, or the design that you made. So, for example, if you have brands like Nike, Adidas, they're all trademark protected. And you can see this from the circle with the R. So this was everything for today's session. Is there any question?
No question.
No question. I will see you tomorrow. Thank you for